Welcome back to the Deep Dive. Today we are tackling a really massive, pivotal question in tort law. When does being old-fashioned actually become legally negligent? We're diving into how established industry practice, what lawyers call custom and usage, affects a claim of negligence, especially when you have, an older installation that clashes with a newer, proven safety standard.
Yeah, this is absolutely critical for understanding just how flexible that reasonable person standard really is. We're going to define the strict legal role custom plays in tort law. Then we'll use an element-by-element framework to really dissect the landmark New York case Trimarco v. Klein. And finally, synthesize those findings into, well, an actionable diagnostic framework for assessing breach of duty when you're looking at exams or real cases.
And the case that grounds all this theory involves a sudden, frankly terrifying moment. A tenant exiting his bathtub when the glass enclosure door just shattered unexpectedly, caused severe injury. This case, it's about much more than just glass. It's about when the passage of time and the development of new safety knowledge transforms something once considered safe into an unreasonable hazard. Okay, let's unpack this. So before we analyze the shattering glass itself, let's nail down the core doctrine. If a defendant is accused of negligence, right, and they claim, hey, I just followed typical industry practice, how much weight does a court actually give that claim? What's the general rule on custom and usage?
Okay, the general rule is, well, it's probably the most crucial part of this whole discussion. Proof of customary industrial practice can be introduced as evidence. It helps show what reasonable conduct looks like under the circumstances. But, and here's the critical distinction, you sometimes hear it called, the Holmes rule custom is never a conclusive or compelling test for negligence.
Never conclusive. Okay, so we're saying custom is strong evidence, maybe, but it's not the final word. Why do courts even allow it as evidence? If the standard is this objective, reasonable person, why should what the industry collectively does matter so much?
Well, its legal potency comes from a couple of places, really. First, custom reflects the collective judgment, the experience, the knowledge of many people in that field. If hundreds of people do something a certain way, it suggests a baseline level of accepted risk, perhaps. Second, and maybe more importantly, it directly addresses the feasibility and practicality of a precaution. That's key. If a safer method is customary, it kind of proves that the safer method is available, it's affordable, it can be done.
Right. I appreciate that clarification. Feasibility is a big part of reasonableness. And if custom is merely evidence, this is where Oliver Wendell Holmes comes in, isn't it? He framed this really beautifully.
Absolutely. The foundational principle is Holmes's rule, essentially. What usually is done may be evidence of what ought to be done, but what ought to be done is fixed by a standard of reasonable prudence, whether it usually is complied with or not. So, in essence, custom informs the reasonable person standard. It gives it context, but it doesn't replace it. The standard is still objective prudence.
Okay. And for this evidence, this custom, to even be admissible in court, does the defendant have to prove that literally every single person in the industry followed this custom? Is the bar that high?
No, thankfully not. The custom doesn't need to be universal. It just needs to be fairly well-defined and occur within the same calling or business. This is a crucial threshold because it allows the law to basically charge the actor, the defendant, with knowledge of that custom, or at the very least, negligent ignorance of it. The idea is, if pretty much everyone else is doing the safe thing, you probably should know about it.
Got it. Fairly well-defined, not necessarily universal. That makes sense. Okay, let's test this doctrine with Trimarco v. Klein. This is the classic example, right? Where custom is used not to defend the defendant, but actually to prove the plaintiff's case. Let's analyze Trimarco v. Klein. First, what are the legally dispositive facts?
Right, so July 1976, the tenant, Trimarco, gets seriously cut when the glass shower door in his apartment shatters as he's getting out. The door is made of ordinary glass, installed years before, looked just like modern safety glass, apparently. The tenant's negligence claim against the landlord boiled down to this. The landlord failed to replace this old ordinary glass with shatterproof material, even though there was a clear, developing industry custom to do exactly that.
Okay, so old glass, new custom.
Yeah.
And what was the core legal issue the Court of Appeals had to wrestle with here?
Well, the issue was kind of twofold. First, did the plaintiff actually present a prima facie case of negligence? Meaning, did they have enough evidence just to get the claim off the ground using this evidence of common law industry custom? And second, did the trial judge mess up badly enough to require a reversal by admitting a specific state statute into evidence that, well, didn't actually apply to this situation?
The rule on custom sounds like it could get complicated, especially with an old installation like this. How did the Trimarco court simplify it? How did they state it as a clear, testable black-letter rule for the jury? What rule of law did the court apply? Can you state the full black-letter rule and break it down into its testable elements for us?
Okay. The court basically established that proof of customary practice, if it's coupled with a showing that the defendant ignored that practice, can establish a prima facie case of breach. And the rule requires the plaintiff to establish three distinct elements to prove breach using custom in this landlord-tenant context. One, the existence of a fairly well-defined customary safety practice. That's element one. Two, the defendant's failure to conform to that practice or, being negligently ignorant of it. And three, that the defendant's deviation from that custom was unreasonable under the circumstances and that this unreasonableness resulted in foreseeable harm.
Okay, three elements. Existence, failure to conform, and unreasonableness of that failure. Thank you. Now for the court's elemental analysis. Let's walk through this step by step like we're building the case. How did the court apply the first element, the existence of a custom? Did the plaintiff prove that?
Oh, yeah. The court found this element was, frankly, overwhelmingly met by the plaintiff's evidence. It was quite strong. They had expert testimony showing that using shatterproof materials for bathroom enclosures had been common since the early 1950s. We're talking decades before the injury.
The 50s, wow, okay.
Right, decades. Furthermore, the managing agent for the defendants actually admitted that local landlords customarily use safety glass when replacing shower enclosures and had done so since at least 1965. And then, on top of that, there were industry safety bulletins warning against using plain glass in hazardous locations, like bathrooms. The conclusion was pretty clear. The custom to use safety glass was definitely fairly well defined and known in the industry. Element one, check.
Okay, so the custom existed, that's clear. But, just because a safer custom exists doesn't automatically make the old door negligent, does it? I mean, the landlord didn't install this door, they inherited it with the building, presumably. Why did the landlord's failure to adopt the custom cross the line into unreasonable behavior? How did the court apply that crucial second element, assessing the unreasonableness of the landlord's conduct?
Right, and this element is where that dynamic standard really comes into play. It's not static. The court basically said, look, this determination is squarely for the jury. The jury had to consider whether that developing custom, especially when you combine it with the, quote, modest cost and ready availability of safety glass, whether all that meant the old ordinary glass had essentially transformed into an unreasonable danger in light of later developments. They were basically asking, was it unreasonable for this landlord to just ignore this cheap, available, safer alternative for maybe 2 decades or more? And the jury, looking at all that, said yes. They concluded the long-term deviation was unreasonable.
Okay, so the jury found it unreasonable. Based on the elements, existence, and unreasonableness, it sounds like a slam-dunk win for the tenant. But the court still reversed the judgment and ordered a new trial. What was the central point of prejudicial error? What went wrong with that statute?
Yeah, this is a really interesting point of conflict in the case, the procedural error. The error was that the trial judge admitted these specific sections, 389 meters and 389 of New York's General Business Law, the GBL. Now, this GBL mandated safety glazing in bathrooms. Sounds relevant, right? But the Court of Appeals emphasized that the statute did not apply to existing installations like Trimarco's glass door. It only applied prospectively to new ones.
Oh, okay.
So, while the existence of the statute might numerically support the idea that a custom was developing, proof that safety was becoming the norm, the court ruled that once it was presented to the jury as this mandatory criminal requirement, it unfairly prejudiced the defendants. The worry was the jury might have thought the landlord broke the law, essentially applying a negligence per se standard, where only the common law standard based on custom and reasonableness should have applied.
Wait, hang on. If the statute only applied to new installations, wasn't it still pretty valuable evidence that the whole industry was moving towards safety glass? I mean, it supports the custom element, doesn't it? Why was omitting it so fatally prejudicial if it really just reflected a general safety trend everyone seemed to agree on?
That's a fair question. It's about how it was presented. The Court of Appeals didn't say it was totally irrelevant to the idea of custom, but they felt its introduction into the, quote, adversarial conflict was done in a way that likely confused the jury. Confused them into thinking the landlord was legally required by this criminal statute to replace the old glass, rather than just being reasonably expected to do so under common law negligence principles because of the custom, cost, and risk. Since the statute carried criminal penalties for non-compliance on new installations, the fear was the jury might have mistakenly substituted that absolute statutory duty for the more flexible common law standard of reasonable prudence based on custom. It raised the stakes unfairly.
Okay, that makes more sense. It wasn't the fact of the statute existing, but how it was used, potentially making the jury think it was a violation of law, not just unreasonable conduct. So after analyzing all the elements of the negligence claim and considering this evidentiary mistake with the statute, what was the court's final conclusion? What was the bottom line?
Well, the ultimate holding was a bit complex, really a split decision in effect. On the one hand, the court held that the plaintiff did present enough common law evidence, the expert testimony, the agent's admissions, the safety bulletins, to sustain a prima facie verdict on the merits. Basically, the landlord was negligent based on the common law custom standard. However, and this is the key part for the outcome, because the improper introduction of that non-applicable GBL statute prejudiced the defendant by confusing the legal standard for the jury. The order upholding the verdict was reversed. A new trial was granted, but it was confined only to the issues of liability and fault apportionment, not damages. They'd have to retry the negligence issue with the proper instructions.
Fascinating. So the custom evidence was good enough, but the statutory evidence messed it up. Okay, here's where it gets really interesting and kind of brings us back full circle to Holmes's rule about reasonableness being the ultimate standard. If custom is merely evidence, not conclusive, what if we found, say, a small but clearly well-defined custom among high-rise window washers in a particular city? Let's say they all agree not to use safety harnesses because, I don't know, they find them cumbersome, they slow them down. If one of them falls, would this custom prove the building owner was not negligent for maybe failing to maintain proper safety anchorage points? Because that's just how they do it here.
Absolutely not. No way. That kind of custom would be Exhibit A for a negligent standard, not a reasonable one. The jury or judge must still satisfy itself with the objective reasonableness of the behavior, regardless of the custom. If the custom itself is inherently dangerous, like, say, ignoring basic life-saving safety gear that's readily available, then adherence to it, or even a building owner's dependence on that unsafe custom, simply fails the fundamental standard of reasonable prudence. That's the core of the doctrine, really. The standard of due care dictates the outcome, not just what people happen to be doing, especially if what they're doing is dangerous. Custom must itself be reasonable.
Right, the custom itself has to pass the reasonableness test. You can't hide behind a negligent custom.
Exactly. And that complexity, especially applying custom in usage when you might have statutes floating around, it really requires a structured approach. So when you encounter this issue, maybe on an exam or just analyzing a situation, you should probably use this kind of four-step diagnostic toolkit to analyze breach of duty based on custom. Step 1, issue spotting. First off, just determine if the scenario involves some safety precaution the defendant didn't adopt. And crucially, is there evidence of an alternative practice being used by others in that field? That's your custom hook. Step 2, establish the custom. Does the evidence actually prove a fairly well-defined practice in the defendant's specific calling or business? Look for concrete proof points, expert testimony, industry bulletins, admissions of practice, replacement policies, just like the plaintiff did in Trimarco. If yes, proceed. Step 3, determine legal weight, the Holmes check. Now, immediately remind yourself, custom is only evidence. It's not conclusive. Say it again, not conclusive. Adhering to a safe custom, that's good evidence of due care. But failing to adhere to a safe custom only raises an inference of negligence. The jury still has to assess the objective reasonableness of that failure. And step 4, evaluate reasonableness, the dynamic test. Finally, focus your analysis on the dynamics of the situation. Think about the cost, the availability, the feasibility of the safer alternative. Did the older practice, maybe once considered safe, essentially transform into an unreasonable danger over time, precisely because the safer material or method became cheap, readily available, and widely accepted? This dynamic assessment, looking at the whole picture as it evolved, is the core determination for the trier of fact, usually the jury.
That's a great framework. What really stands out to me from this whole analysis is how the law is constantly trying to balance things. It's balancing the accumulated experience and knowledge of an entire industry, reflected in custom, against that single, unyielding, universal standard of prudence that's required of everyone. Custom informs, gives context, shows feasibility, but that objective standard ultimately controls.
That is absolutely the crucial takeaway here. It's the separation of proof and standard. Custom provides the data points, the evidence, the context of industry knowledge, feasibility, all that. But the standard of reasonable care, that objective measure, ultimately dictates the legal conclusion. Custom doesn't get the final say. Reasonableness does.
Okay, a final provocative thought for you, our listeners, to mull over as we wrap up. Think about Trimarco. If that New York statute, the GBL, had actually applied not just to new installations, but also retroactively mandating replacement of existing installations like Trimarco's shower door, would that have established negligence per se? Would it have changed the entire nature of the liability, maybe removing the need to even debate the common law custom at all? Something to explore on your own.
Definitely food for thought. Thanks for joining this deep dive.